tonight is Judge Jonathan Walker. And Judge Walker is a sitting judge in El Paso County, and he's been a judge for several years now. Before that, he was a public defender when I was a DA, and Judge Walker was a public defender. We locked horns several times, and I can tell you there isn't a nicer and more ethical and better lawyer than Judge Walker. We had cases where we were opposing counsel and we're friends. So, and I consider it a privilege that he is going to spend some of his time with us tonight. He's been a lawyer for 37 years. 37 years, he's a Vietnam vet. He's litigated some major cases in Michigan and Detroit against car companies. He's been a public defender for the last, for what, 10 years?
Yeah, about 9 years.
And he was the public defender. Yep. And so he's defended murder cases and major felonies. Like I said, he and I, when I was a DA, were opposing counsel with each other. And then he was appointed to district court. So I'm going to let him talk about his biography, and then he's going to go into the role of judges in the courtroom, how they're selected, and what their powers and authority is. So I'm going to bring him in. So if you give me a round of applause for Judge Walker.
Usually I get announced and I sit down and tell everyone else to sit down. That's silly, but he's still not used to that. Okay, well, we're going to go through some procedures, really, from the judge's standpoint, what happens in the court system. We'll first go through the state court system and talk about the different courts and what they're made up of and what their jurisdiction is. Jurisdiction meaning what they do, what they're empowered to do. And then we're going to talk about the selection and retention of judges here in the state of Colorado. It's a little different than many states. And then we're going to talk about courtroom procedure itself. We're going to go through the process, how it works, and remember that everything that happens in a courtroom is guided by rules. It's sometimes litigation has been called a street fight with rules, and it really is. There's an air of decorum, thinly veiling a lot of animosity and stress and so on in any kind of litigation. So by way of introduction, I'm from Detroit originally. I grew up there, went to the University of Michigan, go blue, undergraduate school, and then I went. I got drafted. When I got partway through my training, I realized that I was infantry, and this is 1970, so I knew where I was going next. And I already had my degree, so they said, well, you can be an officer if you want. Go to OCS. I said, no, I don't want to be an officer. What else is available? And they said, well, Special Forces. And I said, well, what do I have to do to be, to go Special Forces? And they said, well, you got to sign up for another year, because it's a 2-year thing when you get drafted, and then a 3-year hitch on that, and you'll have to go to jump school. But chances are you won't go to Southeast Asia. So I took them up on that, and I ended up in Southeast Asia. That's the Army. Then I got out, I got back from Southeast Asia. I had spent 9 months there working with A teams. We were training and deploying some Laotian mountain folks called mountain yards. And we would run them on the Ho Chi Minh Trail and set up ambushes, and saw quite a bit of action during that time. I got back and got back to Fort Bragg, and then they sent me on to Fort Sheridan, Illinois, where I was then made a active duty advisor to the reserve unit for the rest of my hitch, so that turned out okay back in my home state. I then I went to law school at Wayne State University in Detroit on the GI Bill. I was getting $378 a month. I was fat. And went through law school. Got a job with a progressive law firm there in Detroit. Did a lot of civil rights work but also did product liability work, and that's what I learned to do. We sued the auto companies. I did a lot of consumer products, baby products, collapsing strollers, babies strangling on balloon shades, in cribs, and with the bars, above ground pools, ATVs, but my specialty was sort of restraint systems, seatbelts and airbags. In fact, I did the first case in the state of Michigan where the allegation was it should have been an airbag in the car. It was against General Motors. And we settled it for high six figures with that kind of cockamamie theory. I tried cases in 7 or 8 different states, 5 federal courts for almost 20 years. Got burned out. Just couldn't do it anymore. I was like, hadn't had a vacation in years, and was making a lot of money, but wasn't enjoying it, and so I just quit. And I came out here to Colorado. Spent 3 years in Boulder, doing some writing. I lectured at the law school a little bit. Taught at NIDA, which is the National Institute of Trial Advocacy. Came down in the spring. I was, I'm a single guy. I wasn't meeting anybody in Boulder, middle-aged man, and they're college students. I'd see a pretty woman on the street, and I'd smile at her. She'd smile back, and I'm thinking she likes me, and she's thinking, I think that guy's a friend of my dad's. So I moved down to the spring. I got an offer with the Office of the Public Defender, and they sent me here to Colorado Springs. I didn't know anyone here. Well, actually I did. I knew one person here when I came in '98. Worked as a public defender until '07 when I was appointed to the bench by Governor Ritter. And the way judges are appointed, we have what we call a merit selection system in Colorado. That is that the judges are appointed by the governor after being vetted by a series of interviews with commissions and so on. And then they send 3 names up to the governor, and then you interview with the governor. And anyway, I was put on the court in 2007, and then I'm in county court, which is jurisdiction for misdemeanors. So, does anybody know the difference between a felony and a misdemeanor?
Yeah, isn't it like a punishable by a year in jail or prison, and then the fine, the dollar amount?
Well, sort of, yeah. A misdemeanor is punished by jail, county jails. Felonies are punished, maximum penalties, by Department of Corrections, prison. So that's primary difference. So what I do most often is domestic violence cases and driving influence cases, so on. And we'll talk a little bit about those later because it's become a whole, an interesting development with legalized marijuana and people driving and nobody really knowing what the effects are. So cops are making up things. They are, literally. Be surprised. We'll get into that later. So we're appointed by the governor, and then we have to stand for retention elections. I was just up for retention in November for a 4-year term. You don't run, you don't campaign, you don't have, thank God, you don't have to, you don't have to raise money, do anything. You just have to appear in front of a commission. They evaluate your past 4 years and interview you, and then they make a recommendation. You get in that little blue book, you know, you get before you vote. There's a book with all the, anyway, the judges are listed in there too, the ones that are up for retention. And so I've stood for 2 retention elections thus far. And so that's the way we do it here in Colorado, and it started in about 1966. Because the election of judges is really not a good idea. When you think about it, to run an election, it costs a lot of money. And where do you get the money? Well, from lawyers, right? And lawyers have cases in front of you. So it's not a good idea. And you've seen there have been scandals in West Virginia, Wisconsin, other places where the Supreme Courts were literally bought out by in West Virginia coal mine companies, you know, and things like that. So it really is not a good idea to elect judges. This system has the features of the election, that is, that people can approve or disapprove of a judge and vote them out, but there's not the campaigning and the soliciting for funds and all that kind of stuff. When I was practicing in Detroit, and I was all over the country, but Wayne County was the Detroit County, basically, and you'd go up for a motions hearing, and we'll talk about motions later, and the clerk would hand you an invitation to the judge's fundraiser. And this is, you know, 30 years ago, and they were, even then, $150 or something. And if you didn't pony up, they kept track. So next time you came into that courtroom, you'd sit till the last case was called, you know, and so that's one of the dangers and one of the kind of reasons that electing judges is not a good idea. So we have like I said, we have this merit selection system here. So the courts in the state of Colorado, you probably, I don't know if you know this or not, I'll go through the hierarchy for you and just give you a sense of what we have here. We have, of course, the Supreme Court of Colorado. That's the highest court in Colorado. Pretty marijuana. There are 7 members of the Colorado Supreme Court, and they are appointed, and then they have to stand for retention, and they're elected for 10-year terms, or retained for 10-year terms. After the governor appoints them, then they have to stand on the next election cycle. So they, like I say, they have a 10-year term. Below them are the Colorado Court of Appeals. And that's made up of a number of different panels. There are 3 judge panels that sit on the Court of Appeals. And they are also appointed by the governor, and they are retained for 6-year terms, I believe. I think it's 6 years in the Court of Appeals. Same deal. They go to a commission, they review their opinions and so forth, and make a recommendation to the voters. And then they stand for retention for a 6-year term. The appeals to the Court of Appeals are appeals by right. That means when a decision comes out of the district court or the county court, well, county court first, they go to district court on appeal, and then they go to the court, or then they go to the Supreme Court, but only by leave, what we call certiorari. You probably heard that term. That's when the Supreme Court of the United States does the same thing. You have to petition to have your appeal heard by them. The Court of Appeals, as I said, those are appeals by right from the district court. So in a criminal case or a civil case, if you're on the losing side and you want to appeal, you can go right to the Court of Appeals. If you lose there and decide to go on to the Supreme Court, then they have to accept the case before they'll hear it. The district court then they're the trial courts, the courts that you kind of hear about a lot, where they try homicides and sex assaults, felonies, are heard there, and civil cases, a lot of civil cases. for, you know, the strong arm, those kind of characters. A lot of construction litigation. In fact, construction is one of the bigger types of litigation in any of the courts, interestingly enough, because construction projects, if you have any experience with that, you know, there's contracts going this way and that way, and this subcontractor and that subcontractor, and so invariably there's litigation comes out of a big project. A lot of that, and then district court also hears family law, so divorces, and those are awful. You know, people are at the worst time of their life, their family's going to hell, and you know, they're not rational, oftentimes not pleasant, because it's not a pleasant experience, and you know, the district court has to deal with those. A lot of that work is done by the magistrates. Now magistrates are kind of what we call judge light. They can do everything a judge can do, except jury trials. But they are appointed by the chief judge in the district court and not the governor. So they work for, even though they're state employees, they are appointed by the chief judge of the district court. And county court is what I'm in. County court is the court that hears misdemeanors and civil cases up to $15,000. A lot of collection cases, those kinds of things. And we also have magistrates that hear infractions and so on in the county court portion of the courthouse. The district court judges stand for retention for 6-year terms, and county court, my court, we stand for, as I said earlier, 4-year terms for retention elections, having been appointed by the governor. So that kind of gives you the shakedown on the courts and the judges. I wanted to get, so you put everything in perspective. So what I'm supposed to address here are the courtroom procedure and judges. Now, when I took the bench, I'd been a lawyer for 30 years. As I said, trying cases all over the country, 19 to 20 years, civil stuff, product liability cases as a plaintiff lawyer, handling only major, quadriplegia, terrible burns, death, very, very serious injuries, because those cases cost a lot of money to pursue, and so you have to have a case that's, where there's a lot of damage to the family or to the individual. So the thing to remember is that all courtroom procedure is governed by rules. Okay? You have the rules. You have the rules of civil procedure. You have the rules of criminal procedure. You have the rules of evidence. So these things, and I'm going to pass these around in particular. These are statute books, but these happen to, and you'll see I have tab certain things. But there's the Colorado Rules of Criminal Procedure, Colorado Rules of Civil Procedure, and this is just a little guidebook that I use that I got from National Institute of Trial Advocacy that explains the rules of evidence, because that's really what guides everyone in the courtroom, the lawyers, how they ask a question, how they introduce documents, those types of things are all by the book, literally. So I'm going to pass these around. And we'll go into them a little bit in more detail, but let's just start here. Get you started over here. Pass that around. And those burgundy things are the actual statute books that we get every year. There's, I forget how many volumes, 42 volumes, something like that. deals with a particular set of laws. These that I brought were the, I think, court rule books, volume 1 and volume 2 of the rules, and those contain also the rules of evidence and so on that are in that little book. The Colorado Rules of Criminal Procedure, Colorado Rules of Civil Procedure, the County Court Civil Procedure, and just, you know, all the rules that guide how this process works. So, it's the judge's job to enforce these rules and to make sure that everyone is following those rules procedurally. And that is one of our roles, to rule on objections to things. You know, for instance, someone files a complaint in a civil case. There are then motions to dismiss because the other side might say, you know, they violated the rules here. They didn't file this correctly, or they didn't file it in time. Those types of things in civil cases happen. The rules then also govern how discovery is conducted in civil matters. Now, in criminal matters, see, discovery is the production of documents, investigation reports, pictures, anything that is collected and is intended to be used as evidence, or could lead to evidence, in a criminal case must be produced by the district attorney. They have the burden of proof. They have the burden of producing what we call discovery. They're governed in the Rules of Criminal Procedure. Rule 16 is the rule that governs what the DA has to do, what their duties are, and when the timelines of when they have to do it. Then also with the defense, they have fewer rules govern them in the Rules of Criminal Procedure, because, again, in our system, we have the presumption of innocence. And so a defendant in a criminal case doesn't have to prove anything. In fact, you know, sometimes the lawyers in asking the jury during voir dire will talk about jury selection and stuff too, because that's a very important part of what the judge assists in. The defense really doesn't have to do much. I mean, they have to disclose certain things. If they're going to have an expert witness, they have to disclose that witness, or if they have an alibi defense, that is, you know, my guy couldn't have done it because he was on a plane to Chicago. You got to notify the DA of that in advance, and you have to list the witnesses and so on. But the burden in those rules, the rules of criminal procedure, are primarily on the district attorney's office, because, again, they're the ones that are bringing the charges, and they have the burden beyond reasonable doubt to prove that case to the jury. Now, in a Rule 16, there's a motion practice rule that is filing motions. And what's a motion? I was explained to the litigants that come in front of me that their lawyer might be filing motions. They kind of look at you, you know. But a motion is when a lawyer sees something in the discovery that just doesn't look right. And so they file a motion with the court, and they're asking me, as a judge, to do something about it. Now, what we see most often in the criminal law would be things like a suppression motion. Now, what does that mean? Well, suppression is literally what it says. That is to keep out, to suppress certain evidence that the district attorney hopes to present. What I see a lot in the suppression motions are to suppress the stop, because a lot of my cases start out with stop on the street. So, an officer, in order to stop you when you're driving along, they can't just pull you over. Although, you know, that, probably some folks in here would understand the term DWB, right? Driving while black. Well, that is, you know, a notorious tactic. It has been historically, and we've kind of seen it again, I think, this past summer. But in order to stop a vehicle, an officer has to have reasonable suspicion. Now, that's the lowest standard for intervention in a criminal case. And what it is that the officer has to articulate a reasonable suspicion that a law is being broken, has been broken, or is about to be broken. So, oftentimes, you know, they'll see a suspicious car, and lo and behold, one of the taillights is out. That gives them, if they can articulate that in the hearing, that gives them, they have reasonable suspicion. They don't have to be right to pull that vehicle over. And then they can stop, and that's what we call the seizure, when they pull. And this is all Fourth Amendment kind of search and seizure, and Fifth Amendment due process kind of rights. But an officer, an emotion, so you bring a motion, you're representing somebody. You get pulled over, and he ends up with a DUI. So the lawyer gets to discovery, and he brings the client in, and he says, well, it says here you were, you know, you didn't signal when you, or maybe in the report, usually it doesn't say why they pulled him over. A lot of times it won't say. And the guy, you know, the client says, no, you know, I don't think I was doing anything wrong. I don't know why I got pulled over. So you file a motion to suppress the stop. And the officer gets on the stand, and he or she has to say that they had reasonable suspicion that a law was being broken, had been broken, or was about to be broken, to justify that intrusion. And that's what it is. It's an intrusion. Whenever you're stopped, you know, we have freedom to go anywhere we want, right? This is America. And in order to stop you, they have to have that reasonable suspicion that you're breaking the law. They approach your vehicle, and they ask for identification, those kinds of things. They sometimes will say, do you know why I stopped you? And of course, usually you say, you know, well, you were going, you know, this is a 25-mile-an-hour zone, and you were going 35 or something. Okay. And then he or she asks for your license and your documents. So if the officer at that hearing can't articulate that, and, you know, really can't say why he or she stopped you, then the court can suppress that stop. It goes along further than that. Let's say, okay, the cop is able to say, yeah, I clocked him going 45 in the 25 zone. He or she then can approach the vehicle, and they can embark on an investigation. All right, give me your documents. You know, let's see if you have a license and registration, insurance, and so on. But the scope of that investigation has to be within the scope of what they stopped you for. Now, see, the judge has to determine all this in a hearing, an motions hearing to suppress. So the officer would then, you know, be able to have a limited time to investigate that particular event that he or she pulled you over for. You know, in other words, they can't pull you over and then start saying, I want to look in your trunk, you know, and you start going in the trunk, because there's no way, if he stopped you for speeding, that there would be any evidence of speeding in the trunk, right? So, but, you know, so if that were the case, then that whole stop would have been illegitimate, and the case would get dismissed. So then let's assume they pull your client out of the car and they get him outside the car and they decide to start rummaging through the car. They do this in some police departments. I've seen it recently up in Monument. Terrible case. But there's a U.S. Supreme Court case called Gant in Arizona, G-A-N-T, that says that you cannot do a search of the vehicle without either a warrant or the permission of the driver. In Gant, they had the driver outside the car, and I think he or she was handcuffed, and they went in the glove compartment, got a gun. They charged him with possession of a firearm or something. And the U.S. Supreme Court went all the way up to the U.S. Supreme Court, and they said, you can't just, there was no, the gun had nothing to do with why he was stopped. There was nothing, it wasn't for officer safety that you searched the vehicle, because he was in handcuffs, he's outside the car. He's not a danger to you anymore, even if he had a gun. So you can, as the judge in a motion hearing like that, you can suppress that gun, that evidence, because it was gained illegally. The cop had no business going in your glove box to look for a gun when he pulled you over for speeding. Had nothing to do with nothing. So you get motions like that to suppress the stop, to suppress a piece of evidence that might have been found in a search if the search was illegal. Statements. They get you out of the car and they put you in the back of the cruiser and they start asking you questions. And you say, yeah, I just left Tony's and I had, 6 beers and 2 shots. You've just incriminated yourself, right? Because with 6 beers and 2 shots, you're drunk. A drink is about 0.02 alcohol. You get to 0.05, you're deemed to be impaired. You get to 0.08, you're under the influence. So they move to suppress the statement that you made. This is a motion, okay? So the court has to decide that. I have to decide that. So the inquiry is whether or not, now, we all know from TV and everything, you have a right to remain silent. Anything you say could be used against you. You have a right to a lawyer, the Miranda warning. Well, they only have to give you a Miranda when you are in custody, all right? Now, what's custody? There's a whole library full of stuff about what is custody. But generally speaking, it's if you're free to go, then you're not in custody. They are entitled, even now, okay, so you're in the back of the cruiser, and you can't get out because there's no door handles, right? But they say, no, he wasn't in custody, he was, we were just doing our investigation, and so I didn't have to give him Miranda, and I can ask him anything I want, and sure enough, he told me he'd been drinking. So then the court has to decide whether or not that person was in custody for the purposes of Miranda. Another twist on that would be a seizure. Remember we talked about the seizure. Pull you over, go up to your car, and you're seized. You can't go at that point. The notion is whether, let's say you're parked. You park the car and it's a parking lot, and you got your window down. It's summer. You're waiting for your ride, or somebody that you're going to give a ride to. So a cop just comes over your vehicle, starts talking to you. Well, you're free to go at that point. You can say, "Excuse me, officer, I got to go. My ride, my rider, my passenger's coming, I'm gonna leave. That's what we call a consensual encounter. Now during that, so you're not seized, it's sort of, you know, you're free to go. Kind of thing. You know, you may have seen that. They'll walk up to you in a park, you might be sitting around in the park, and the cop will just come and walk up to you and start walking. They're kind of looking around to see, you know, where you hid the weed or whatever. But that is a consensual encounter. That is, you could get up and go. Conceivable. Right. The reality is different. You know, oftentimes. I always used to get asked, you know, I have a client, and say, you know, this cop just, you know, pulled me out of the car and just started going through grabbed my wallet and started going through everything. Can he do that? He said, he did it, didn't he? So, you know, the issue here is when you do have an encounter, you just don't fight it. Just go with it, because you can't win that battle on the street. You might win later in a suppression hearing in front of a friendly judge, but you know, you don't win it on the street. You just don't. So when the clients who say, "Can you do that?" Why are you here? You did it, right? So the answer to that is yes. But the question is whether there will be his comeuppance for that later on in a courtroom. So those are the motions, okay? In a criminal case, and we're going to talk about how that plays out. But there are motions in civil cases, of course, too. You know, civil is a whole different ballgame. The burden of proof is entirely different. It's by a preponderance of the evidence. That's about 51%. That's the burden of proof, and it's on the plaintiff, the person bringing the lawsuit, right? Now those cases come into a judge after the complaint's filed, and then the judge will have a meeting with the parties and usually issue a case management order, which dictates the way that the parties are to take up till the time they go to trial. So you can take these depositions. Now, deposition is sworn testimony of a witness. It's done in a conference room. Sometimes done on video. I think nowadays they're almost all done on video. But it used to be a court reporter, and the parties can cross-examine and question the witness. And there's no judge there. You can object, but they'll answer the question anyway, and then a judge rules later if that question was proper. You know, if you bring another motion, right? So anytime you have an issue in a criminal case or a civil case, you file a motion with the court, and then the court, after argument, makes that decision whether or not. And in civil cases, it's whether or not you can depose this witness, for instance, and how many. The case management order is going to tell you how many interrogatories you can set. Interrogatories is just a legal word for questions, written questions. Another pleading or another type of discovery in the civil cases are requests to admit. So, for instance, we'd be suing the General Motors, and you know, let's say on the ignition switch, right? You would admit, you would send them requests to admit, so you get a lot of the issues out of the way before you get to a trial. You know, please admit that you, in fact, the Saturn, the 2003 Saturn was designed by General Motors. Please admit that the ignition switch was sold to you by so-and-so, you know, whatever company sold the thing, or, you know, that the airbag was made by Tanaka, and those kinds of things, you know, those are requests to admit. So that's also part of discovery in a civil case. And the court rules don't cover the details of discovery in civil cases as much as they do in the rules of criminal procedure. That Rule 16 is very specific. And again, why? because you got somebody's liberty at stake. That's the key that you have to remember, the difference between criminal and civil. Someone's liberty. Civil cases are money, or, you know, in the case of divorce, those types of issues. But no one's going to jail. But in the criminal law, of course, that is the bottom line, is that you're depriving someone of your freedom. And that's why that standard's way up here, beyond a reasonable doubt. And civil cases are down here with preponderance of the evidence. Then you have different degrees between those for different kinds of cases. Clear and convincing, I think if they want to take your children away, even that is a lower standard of proof than putting somebody in jail, beyond reasonable doubt. So that's the reason that the rules, and the rules that the judge has to enforce, are so much more strict and strictly construed, and very little room for wiggle in the criminal arena because of that key point. Somebody's liberty is at stake. So, in a criminal case, it is the judge's role to make sure that that presumption of innocence remains with the accused, that he or she is given due process. That is, that the DA and the police have to follow the rules. That's all very, very important in criminal law. And again, why? Liberty. There's nothing you can take from somebody that's any more valuable than their liberty. So that's why our laws are set up like that. Now, so motions, you get, in civil cases, you get the motions, I want to take this guy's deposition, and, you know, they got to produce them, and this kind of thing. In the criminal cases, it's to, motions to suppress evidence, to suppress a stop. Sometimes there's child witness type of stuff. For instance, there's a presumption when a child is of a certain age, and I think it's around 7, where they may or may not be competent to testify. I think below 6 maybe in Colorado, that there's a presumption that they're not able to testify. So, but when they get around 6, 7, and up to maybe, 10 or 12, something like that, a DA would bring a motion with the court to allow child hearsay. The notion being that this person is incompetent as a witness because of their tender age. And so the judge has to bring them in. And I have a sheet here on, it's sort of a guideline on the child hearsay. And this is a guideline that I have used, given me to determine. So the DA says, hey, we got a little kid here, and he or she can't really testify. She's 4, but she saw mommy get hit by daddy, and that's what she told the cops. And maybe she doesn't know, how to testify. So it's up to the court to hear her. So you bring her in, and and it says this. These factors are to be considered as aids or guidelines and are helpful in providing, quote, assistance and guidance, but they're not mandatory. The factors set forth below are summarized from past cases. Now this is what the judge is looking for, to see if this kid can testify, or if the DA can bring in police officers to testify. And now hearsay, I probably should step back a minute. Hearsay is an out-of-court statement made by a person, right? It's generally, as a general rule, hearsay is not admissible in court, right? So if that person isn't there, you can't say, oh, well, Joe told me he saw this guy hit his wife. Well, Joe, who's Joe? And it's a question of reliability. How reliable is that? And the person isn't subjected to cross-examination. So if they were allowed to say, yeah, Joe saw Pete hit Mary, well, you can't question Joe because he's not there. You don't know if he has 20/20 eyesight or he's blind as a bat. You don't know if he was standing 10 feet away or he's across the street. You don't know, you can't, his testimony can't be tested by cross-examination. Cross-examination is the crucible under which we test witnesses' testimony. And so hearsay is not allowed. So with a kid, they say, okay, this child is not able to testify, and we want to present his or her statement through the officer that responded. So I put the kid on the stand, and these are some guidelines, and I asked certain questions, but does the child use age-appropriate language? What is the likelihood of the child would have the knowledge that they're going to testify to? In other words, where were you? Do you remember this incident? And you got to be very careful of this because you don't want to, first of all, you don't want a kid in the courtroom. You just don't. I mean, it's not right. It shouldn't be right. But nonetheless, if they have something to offer, then, and then you look at spontaneity, whether the child was responding to leading questions. Now, a leading question is when you've given someone the answer, basically. So, I could say, what's your name? And that's a direct question, right? I'm not suggesting any answer. Your name's Pete, isn't it? That's cross-examination. You're giving them the answer. See? So that's a leading question. It suggests the answer that your name is Pete. Or yeah, that car that he drove up in was a Ford, wasn't it? Yeah. Yeah. Okay, so that's what we call a leading question, and it's used in cross-examination and not direct examination. We'll go through that with what the judge has to do there as well. So time lapse between the event and the statement. The kid, again, how long ago was it before they talked to the police? And the motive or bias of the child or witness reporting. So, the kid doesn't like dad or doesn't like mom or has been coached by one or the other. You try to determine that. Intervening events, how long has this been? What else has happened? Is the child mixing up maybe a series of events, and the chronology of them, or when they happen? Chronology is when they happen. Whether one or more people heard the statements of the child. Consistent repetition, in other words, can the child tell the story the same way? Twice, 2, 3 times? So you ask them those kind of questions. Contemporaneous demeanor evidence. I look at the child and see, are they looking at mom to get a hint of what to say? Are they looking at dad? Those kind of, or is what the child's saying is what they're saying, and not what mom or dad has told them in the car on the way over to say. So that's the kind of thing that a judge does to determine witness. And I'm going to pass this around as well. You can start with that. Let's see, we get through the motion period of a case, the motions back and forth. Now, the way a case is started in the state system is that the district attorney files an information information is just the charges, the list of the charges, and a factual basis for the charge. In Colorado, felonies, we have 6 classes of felonies, 1 through 6. Felony 1 being the worst. That's, life imprisonment, no parole, first-degree murder, first-degree kidnapping, arson maybe, certain arson.
Certain arson with, yeah,
First,
or
Yeah.
serious bodily injury.
felony 2, and F2, F3, F4, F5, F6. F6 can carry a jail term of a year to 18 months, a 5, 1 to 3 years, a 4, 2 to 6 years, a 3, 4 to 12. 4 to 12, I haven't done felony in a year or so. But anyway, those are the levels of felonies. And so the charges are filed, and then the party has the right, if they're in custody, they're arrested on the charge. Okay, a police officer comes to a judge, gets a warrant for someone's arrest. And they lay out probable cause. Now, we talked about reasonable suspicion before. Okay, so first you go, that's the lowest. If you were to go, start at the bottom, and these are the levels of proof, reasonable suspicion. Excuse my penmanship. Okay, that's that. I think a law was violated, or is going to be violated. The reason to stop somebody, either in a vehicle or on the street, reasonable suspicion. Then you move up to probable cause. Now, probable cause means more likely than not. In order to get a warrant to search a house or a car, or nowadays, actually, about 75% of the warrants I sign are for electronic devices. It's amazing what law enforcement has done with telephones and emails and Facebook. Do you know that Facebook keeps every single message ever sent? And somebody told me there's like 1 billion a day. They have, on their campus out in California, they have one building, like a 4-story building, exclusively devoted to storing all the messages that you've ever sent on Facebook. It's pretty scary. And they can turn them over to law enforcement if they're presented with a warrant, a search warrant. So, officer comes in, an officer's exam, let's say, and they use it in everything from murder cases to drug possession cases to all kinds of things. They come to a judge and ask for a warrant. And they lay out the facts of why they believe, let's say they want to search a phone. Let's say there was a couple back and forth, there's an allegation of a violation of protection order, let's say. Okay? Woman gets a protection order against the guy because she felt threatened, and he's harassing her, and so she gets a protection order. And so she calls the police because this guy's been texting her, or calling her, or so on. So the officer will then go talk to her, and she'll agree to let him look at him or her look at her phone. So he gets this stuff pulled off the phone. And then he prepares an affidavit for me, for the judge, and says, I got reason to believe that John was married to Mary, and they broke up, and he had been threatening her, so she got a protection order. And now he has texted her, 300 times, or he's been by the house. So how do we find out if he's been by the house? Well, he or she, the officer prepares this warrant request for me. I look to see if it's more likely than not that the evidence they want could be found on his cell phone. See? So they go get his cell phone, they seize it, and they go into it. And again, when I started on the bench, it'll be 8 years in May, June, about 75% of the requests for searches were vehicles or premises, houses, apartments, so on. The most common thing is, I made a drug deal, you got the drug cops, the V&I, vice narcotics cops, they're undercover. They, okay, I went to this house and I bought meth. And, I went there 2 or 3 times to buy meth. Or this guy sold me meth, and then we had our other unit follow him back, and he went back to this particular apartment. So we want to search that apartment because we feel that that drug dealers leave money in the stash house. They might have drugs there and might have weapons and so forth. So they fill out this affidavit, and if I find that there's probable cause to believe, or it's more likely than not, that this evidence is found on the phone, in the apartment, wherever it is, I sign the warrant. They can then seize that, or really execute the search warrant. Usually in phones, they already have the phone. Like they'll go get it, they arrest the guy and they take it in his property, but they have to, or they tow their car. But before they can search it, they gotta come get a warrant if the person doesn't consent to the search. So they have probable cause right here to search. Okay, probable cause comes in again in the felony cases. Remember I was saying there are certain levels of felonies where you are entitled to a probable cause hearing. Okay, so they file the information. You're charged with a crime. You are charged with a Class 1, Class 2, or Class 3 felony. You are automatically entitled to what we call a probable cause hearing or a preliminary hearing. And that's where the police present their case. If it's a death case, murder, the coroner comes in and says, yeah, they're dead. And the cause of death was a bullet in the head or whatever. They'll say cause of death and manner of death. Cause is the bullet in the head, manner homicide or suicide or whatever. So you're entitled to that hearing if you have 1, 2, or 3, or if you're in custody, if you haven't bonded out. Because every offense you're entitled to bond, except one, and we'll talk about that in a minute. So you're entitled to a preliminary hearing where they have to show probable cause. That, it's more likely than not that a crime was committed and the person accused was the person that committed that offense. So you have a hearing in front of the judge hears that, and he or she decides whether or not there's probable cause to believe that a crime was committed and that the person seated at that defense table is the person that committed it.